Hi. In this video, we're going to review some of the rules that we've learned concerning contract formation. Let's start by talking about assent. The general rule is that a court will not enforce the defendant's promise if the plaintiff actually knew, or a reasonable person would have reason to know, that the defendant was not assenting to be bound. We saw an example of this rule in Lucy v. Zemer. In that case, the Zemers argued that they were just joking when they promised to sell Lucy their farm. But the court rejected that argument. They concluded that Lucy thought they were serious, and that a reasonable person would have no reason to know that they were joking. Now let's talk about offer and acceptance. Here the general rule is fairly straightforward. If the plaintiff alleges that the defendant made a promise as part of a bargain, a court will not enforce the promise unless the plaintiff can prove the existence of both an offer and acceptance. What makes this general rule difficult is we've seen at least 18 specific rules on when there is an offer and when there is an acceptance. Bear with me, because I want to go through all of these 18 rules. First, we saw that an offer is a manifestation of a willingness to enter a bargain conditioned on the offeree's acceptance. We saw several cases that applied this general rule. One of them was Owen v. Tunison. In that case, Tunison said that he would not be able to sell his property unless he was to receive $16,000. The court, however, said that wasn't an offer. He wasn't manifesting a willingness to sell for $16,000. He was simply saying he wouldn't sell it unless he got $16,000. Secondly, we saw that advertisements generally are not offers unless they state a limited quantity or have other attributes indicating that the advertiser actually intended to make an offer. We saw an example in Lefkowitz v. Great Minneapolis Surplus Store. In that case, an advertisement to sell one lap-in stole to the first person who showed up was considered to be an offer because it was limited in quantity and actually indicated that the surplus store wanted to make a bargain. Third, in general, we saw that an offer terminates and cannot be accepted after the offer lapses because of the passage of time, the offer has been revoked by the offeror, the offer has been rejected by the offeree, or the offeror has died. Now the next couple rules elaborate upon these principles. Rule 4 is that an offer lapses after the time specified or after a reasonable time if no time is specified. Rule 5 is that revocation of an offer is effective when communicated directly or indirectly to the offeree. In Dickinson v. Dodds, for example, the court held that Dodds effectively revoked his offer when Dickinson learned that Dodds was attempting to sell the property to someone else. 6. An offeror generally can revoke an offer at any time before acceptance unless the offeror has made an enforceable promise, called an option contract, to keep the offer open. In Dickinson v. Dodds, Dodds promised to keep his offer open until Friday, but the court held that this promise was not enforceable because there was no basis for enforcement. He hadn't received any consideration. If he had received consideration, then he couldn't have revoked his offer. Now, a few courts hold that an offeror cannot revoke an offer if the offeree has relied on the offer, even if there's been no promise to keep the offer open. We saw an example of that in Drennan v. Paving. But not all courts accept that view. 8. We saw a counteroffer is presumed to be a rejection of an offer. So if the offer is to sell 2,000 tons of rails, and the offeree proposes to buy 1,200 tons of rails, that's not just a counteroffer; it's also a rejection of the original offer. We also saw, under the mirror image rule, that a purported acceptance of an offer that contains different or additional terms is treated as a rejection and as a counteroffer. In the Minneapolis and St. Louis Railway against Columbus Rolling Mill, for example, when the Columbus Rolling Mill offered 2,000 tons of rails, and the Minneapolis and St. Louis Railway said, "We accept 1,200," that was deemed to be a rejection of the original offer, not an acceptance, but instead a counteroffer to purchase 1,200. 10. We saw that an offer terminates upon the death of the offeror, even if the offeree does not have notice of the offeror's death, unless the offeror has entered an option contract to keep the offer open. The Earl v. Angel problem dealt with this rule, And as we saw in that case, it can be very important to determine when exactly the offeror died. 11. Under the mailbox rule, unless the offer specifies otherwise, acceptance occurs upon dispatch of the acceptance. It doesn't have to be dispatched through the mail. It could be dispatched by some other means, say by Federal Express or UPS. But as soon as it leaves the possession and control of the offeree, there is an acceptance. 12th, we saw that an offer may invite the offeree to accept either by rendering a complete performance or by promising to render a complete performance. The offeror has the choice of what type of offer to make. Now, if the offer invites acceptance by the rendering of a complete performance, acceptance does not incur until and unless the offeree completely performs. So in Carbolic Smoke Ball case, Carbolic Smoke Ball invited the offeree to accept by performance, namely by purchasing the product and using it for 2 weeks. No acceptance could occur until those things had happened. 14. An offeree may accept by making a promise to render complete performance, either expressly with words or implicitly through some sort of conduct. Now, the confusing thing about accepting by making a promise to completely perform is that the most common way to make an implicit promise to render complete performance by conduct is to simply start performing. But that's not the same thing as accepting the contract by performance. It's accepting the contract by making a promise. It just happens to be that the start of performance is an implicit way of making a promise. That was the argument in White v. Corlies and Tift. White argued that he had made a promise to do the work by starting to cut up the wood. Similarly, Ever-Tite Roofing v. Green, Ever-Tite Roofing promised that it would do the work by loading up the trucks and driving out to the Green's house. Now 15, even if the offer describes one manner of making a promise, the offer also may permit other manners. So for example, in Allied Steel v. Ford Motor Company wanted Allied Steel to make a promise that it would do the work. It indicated that Allied Steel should make the promise by signing a piece of paper and returning it. Instead, Allied Steel simply started work, but the court concluded that by starting work, Allied Steel was promising to do the work, and that although Ford Motor Company had suggested one manner of acceptance, other manners were also acceptable. Rule 16 is that the offeree's silence cannot be acceptance except in a few special cases, such as when the party's course of dealings makes silence a proper method of acceptance. So Hobbs, in Hobbs v. Massasoit Whip Company, sent some eelskins to Massasoit. Massasoit didn't say anything, but the court held that the silence was acceptance because the party's prior course of dealing had indicated that silence could be an acceptance. Rule 17 is that if the offer invites acceptance by making a promise, notice of acceptance is required unless it is waived. And that was the problem in White v. Corlies and Tift. Even if White was making a promise, an implied promise, to do the work when he started to cut up the wood, Corlies and Tift never received notice of that implied promise before they rejected the offer, or revoked the offer. Rule 18 is that if an offer invites acceptance by rendering complete performance, notice of acceptance is not required unless requested. So, for example, in Carlill Carbolic Smoke Ball, Mrs. Carlill did not have to notify the Carbolic Smoke Ball Company that she was purchasing the product and using it for 2 weeks. That wasn't required because all Carbolic Smoke Ball Company wanted was a performance. Now, how do these rules translate into arguments that the defendant might make? Well, the defendant is going to essentially argue that the plaintiff can't show either an offer or acceptance. And the plaintiff has essentially 11 arguments for why that's true. First, the defendant might simply argue that there was no offer under the definition of an offer. There was no manifestation of a willingness to be bound upon the offeree's acceptance. That's the argument that we saw in Owen v. Tunison, Harvey v. Facey, Fairmount Glass, and the Lefkowitz stores. Second, the defendant may argue that the offer lapsed before the attempted acceptance. Third, the defendant may argue that the offer was revoked by the offeree before the attempted acceptance, and there was no valid option contract precluding revocation. That was the argument that was made and that succeeded in Dickinson v. Dodds. Fourth, the defendant may argue that the offer was expressly rejected by the offeree before the attempted acceptance. Fifth, the defendant may argue that the offer was implicitly rejected by the offeree because the offeree made a counteroffer. That's the argument we saw in the Minneapolis and St. Louis Railway v. Columbus Rolling Mill case. Sixth, the defendant may argue that the offer terminated before the attempted acceptance because the offeror died. We saw that in the Earl v. Angel problem. Seventh, the defendant could argue that the offeror invited acceptance by the rendering of a complete performance, and the offeree did not render complete performance. Mrs. Carlill wouldn't have a contract if she merely purchased the product. She'd also have to use it for 2 weeks. Eighth, the offer invited acceptance by a promise to render complete performance, and the offeree did not make such a promise either expressly with words or implicitly with conduct. That was an argument that the defendants tried in both White v. Corlies Tift and Ever-Tite Roofing v. Green. Ninth, the defendant could argue the offer invited acceptance by promise to render complete performance, and although the offeree made a promise, the offeree did not make the promise in a manner invited by the offer. That's the argument that Allied Steel made in the Ford Motor Company. That's the argument that Allied Steel made in the Ford Motor Company case, but it didn't work. The 10th argument is that although the offer invited acceptance by silence, and the offeree was silent, the offeror could not insist that silence would be acceptance. And the 11th argument is that the offer required notice of acceptance, and the offeree did not provide notice of acceptance. Again, we saw that in White v. Corlies Tift. Those are different arguments that the defendant can make for why the plaintiff cannot show a proper offer and acceptance. Now, in addition to talking about offer and acceptance, we also talked about indefiniteness. And we saw there that a promise is too indefinite to enforce if the court cannot determine the existence of a breach or the appropriate remedy for a breach. Varney v. Ditmars, for example, Ditmars promised Varney a fair share of the profit, but the court said, well, we don't really know what that means. Now, one thing we did see is that a court may require less definiteness if the plaintiff seeks to enforce the promise by means of promissory estoppel than as part of a regular bargain. Those are some of the rules that we've seen concerning offer and acceptance. Thank you very much for listening.